Under the Administrative Procedure Act, or APA, courts may generally review an administrative agency's actions, including agency rulemaking. However, if the agency's actions are committed to agency discretion by law, they're presumably unreviewable under the APA. But what if an agency enters into agreements or settlements where it defers enforcement of certain statutes? Are these agreements reviewable under the APA? The D.C. Circuit Court of Appeals considered this question in Association of Irritated Residents versus EPA. Under the Clean Air Act, the Comprehensive Environmental Response, Compensation, and Liability Act, and the Emergency Planning and Community Right to Know Act, the Environmental Protection Agency, or EPA, has the authority to regulate certain air pollutants. Animal feeding operations, or AFOs, emit a number of pollutants that are regulated by the Acts. To be subject to the Act's requirements, an AFO must emit pollutants in sufficient quantities. As a result, the EPA must determine the level of an AFO's emissions. But in the early 2000s, there wasn't an existing methodology to reliably measure an AFO's emissions. As a solution, the EPA invited AFOs to sign consent agreements, which in essence were settlements. The agreements required the AFOs to pay civil penalties for potential violations based on the AFO's size. The money would then be used to fund a study to help develop emissions estimating technology. In exchange for signing the agreements, the EPA agreed not to pursue administrative actions and suits against the AFOs for a specified period of time. Many agreements were signed by AFOs. Subsequently, several community and environmental groups, known as the Association of Irritated Residents, filed a petition for review of the agreements in the D.C. Circuit Court of Appeals. The groups argued that the agreements, which were intended to eventually bring the AFOs into compliance with the Acts, constituted rulemaking and violated rulemaking procedures. In response, the EPA argued that the agreements weren't rulemaking but a valid exercise of its enforcement discretion by law.